Anyone and everyone is free to cover their head, their faces, wear a hijab, burqa or a ghungat in India. There is no law that tells women how they must dress. It's a free, democratic country. The debate pertaining to hijab in India is a very different one. The debate is the clash of two established norms. One, about individual religious expression, which is about wearing a hijab, tilak or a sindoor. And the other is about freedom of the government-run schools and colleges to frame their own rules. It's a debate of institutional autonomy versus religious rights. The question that the courts are attempting to answer is not whether Muslim girls can wear a hijab or not. Of course they can. But whether hijab can be worn within the classrooms, especially when the College Development Committee thinks otherwise. Hello and welcome. We talk about the Supreme Court verdict on the hijab matter. The top court has given a split verdict, which means that there were two judges on the bench and both had different opinions on the matter. In the absence of a finality from the top court of the country, it is the Karnataka High Court judgment which is the law of the land. What does that mean? It means that hijab ban in government-run schools of Karnataka stays. Let's come to another aspect. Why did the judges differ in their opinion? What have the judges said on individual rights and liberties? To what extent can religious expression be placed over and above institutional norms? Let's begin by tackling some core arguments. The first one, and you must have heard the buzzword these days, called the Essential Religious Practice Test or the ERP. Well, here's a fascinating bit. Our constitution has no definition to the word religion. There is no exhaustive definition and the courts interpret it on a case-to-case basis, which makes it all the tricky to see when the occasion arises what is an essential religious practice. Hence, you often see courts reading Gita, Quran or a Bible or other theological sources to determine what a religion and its practices are. Let's talk about one of the judges on the bench. Justice Gupta, one of the judges on the bench of the Supreme Court, said that hijab is not a part of the essential religious practice. Justice Gupta, in his judgment, emphasizes that all practices of the religion cannot be termed to be essential. Now, quoting an interesting case, he argues that Quran permits a Muslim man to marry 4 times. But if he doesn't, the Muslim man doesn't cease to be a Muslim just because he hasn't married 4 times. Contrary to the presumption, Justice Gupta categorically says that state-run schools cannot discriminate on the basis of religion. Then on what ground has he upheld the High Court order? The judge has upheld the order based on the ideal of a welfare state, the ideals of reform, the schools being secular institutions. The opinion is that any believer is free to carry his or her own religious beliefs. So whether hijab is social, cultural or religious, but if the state has framed a rule for reform and welfare, it must be respected. Also, to promote uniformity among students, it must be followed, and it's a reasonable restriction by the state. Justice Dhulia, the other judge on the bench, disagrees with the ban on hijab in Karnataka schools. But interestingly, even he notes in his judgment that the path taken by the petitioners in the case, which is to evoke the essential religious practice argument, is not the correct one. In the opinion of Justice Dhulia, the case for wearing hijab can be made out simply by asserting individual rights and liberties, the fundamental rights of any individual. Courts, according to him, should not be the forum for adjudicating theological dispute. That's what the judge says. The two judges, though, have divergent opinions but seem to have one similar advice for the Muslim side. The argument of essential religious practice may not find much merit in law when it comes to the hijab debate. Other than the essential religious practice argument, there's another facet which is interpreted very differently by the judges. The duty of the welfare state to reform and to educate. Now, both judges talk about the concept of welfare and reform, but they take very different approach. While one judge on the bench, Justice Gupta, believes that a school uniform promotes a sense of openness and unity, uniform ensures objectives of social and cultural reform, reforms which are enshrined in Indian Constitution. The other judge believes, which is Justice Dhulia, that with this ban, the right to education of girls is affected, which should be protected at any cost. The state must accommodate such beliefs for the larger interests. Justice Gupta notes that if you're not coming to school because you want to wear a hijab in a classroom, it's a voluntary choice. The other judge on the bench believed that it's an attack on the dignity of a Muslim woman if they are asked to remove hijab before entering the classrooms. Justice Dhulia further goes on to say that the 9-judge verdict that asserts privacy as a fundamental right in this country is the right path for the Muslim side to pursue. It is asked in the judgment that if a Muslim girl wants to wear hijab, is it too much to ask in a democracy? Hijab should simply be a matter of personal choice and not a question of essential religious practice, according to the learned judge Justice Dhulia. Now, with these divergent opinions, where is the debate headed? The sharp polarized opinions that you hear in public or in political debates, they have clearly resonated in the judicial corridors, in the courtrooms as well. The Supreme Court will have to constitute a larger bench to hear this matter. The petitioners may or may not take the path or the argument of essential religious practices before the larger bench. We'd have to wait and watch. But the hijab debate has exposed some crucial questions of law and religion that must be answered by the top court of the country, preferably by a constitution bench. First, what are the limits to religious expression in state-run institutions, especially schools? If schools are secular places, then should all kinds of social or cultural activities be prohibited? In a country like India, is it even possible to draw a sharp distinction between what's religious and what's cultural? And what shall be the limits of religious expression in this country? Can regressive practices be shunned by government in this way through notifications? More importantly, can there be an exhaustive, conclusive definition of what is an essential religious practice? Whatever the court may decide in the hijab matter will have far-reaching consequences, not just about religious expression, minority rights, but for various other debates pending in the Supreme Court pertaining to personal laws. The hijab debate also throws up questions of minority rights versus the ideals of reform.